Imagine this. You discover something suspicious about a will or trust. Maybe a new document suddenly appeared. Maybe someone pressured your parent to change their estate plan. Or maybe the trustee refuses to answer basic questions. You want to start looking into this. But here's the dilemma. You might be right about your suspicions, but in probate court, if you're too late, the judge may not even hear your case. That's because probate cases have strict statute of limitations. But before I go any further, let me quickly introduce myself. My name is Angelique Hamani. I'm an educator, not a lawyer. I'm someone who had to represent myself in probate court because I couldn't afford a lawyer. The content of this video is for educational purposes only and not legal advice. So what is statute of limitations? Statute of limitations is basically a legal deadline. It determines how long you have to bring a case to court. These deadlines exist for one reason: to bring finality to the administration of an estate. At some point, the law wants the estate settled so assets can be distributed and people can move on. That's why probate courts strictly enforce these deadlines. Let's start with wills. If you believe a will is invalid because of fraud, forgery, lack of capacity, or undue influence, the law gives you two main windows to act. First, you can object before the will is admitted to probate. But once the court formally admits the will to probate, meaning the judge accepts the will as the controlling document for the estate, the second window begins. Under California Probate Code Section 8270, you generally have 120 days from that court order to file a petition to challenge the will. Trust disputes follow a similar timeline to will contests. The difference is that the clock usually begins when the trustee sends a formal notice to beneficiaries and heirs. This notice is called a notification by trustee. It comes from California Probate Code 16061.7, which basically tells beneficiaries that a trust exists and that the 120-day clock to challenge it has started. There's one important detail that needs mentioning. If the trustee sends the notice but does not include a copy of the trust and you request it, the law may give you 60 days from the date you receive a copy of the trust or the original 120 days, whichever is later. Not all probate disputes involve the validity of a will or trust. Sometimes the issue is how the trustee or executor is managing the estate. For example, hiding assets, misusing money, or refusing to provide information. These cases are usually called breach of fiduciary duty. Under California Probate Code Section 1640-60, the statute of limitations often begins when the beneficiary discovers the wrongdoing, or reasonably should have discovered it. In many cases, that deadline is about 3 years from discovery, although a formal trustee accounting can sometimes shorten that deadline. This is sometimes called the discovery rule. The key point is this: probate courts will not hear a case if it's filed too late, even if something was blatantly unfair, even if fraud or undue influence is evidence. If the statute of limitations has passed, the court may dismiss the case without ever hearing the facts. In other words, if the deadline passes, the courthouse door may already be closed. So, a quick reminder of the 3 requirements before bringing a probate case. You should ask yourself these 3 questions. 1. Are you acting at the right time, within the statute of limitations? 2. Are you the right person? In other words, do you have standing? And 3, are you in the right place? Meaning, do you have the legal grounds that belong in probate court? If all 3 of those requirements are met, then you may have a probate case worth exploring. If you'd like help thinking through your situation, you can take my free quiz. You can find the quiz link below in the description, called Do I Have a Probate Case? It walks you through the same questions we discussed in this video, and it helps you start evaluating your situation. In addition, you'll also receive a probate evidence checklist to help you begin organizing the documents and information that may matter in a probate dispute.